Thank you, Mr Acting Deputy President. It's a good opportunity now to continue my remarks which I made last night on this bill. This bill is part of the government's broader agenda to strengthen our border security. It was a key component of the policies that the government took to the last election, and it's been a great success since then. It's been such a great success that, of course, the Labor Party have now adopted the policies of the coalition. They've finally seen the light. They took many years to see the light, but they finally have. That we do need to have strong borders to save lives and create a secure nation for the people that live here. This bill is only a small change which will help provide greater power and options for the employees that put their own safety at risk in our detention centres. Our detention centres are, of course, now peopled with fewer people, thanks to the government's border protection policies. There are fewer people arriving here irregularly. There are fewer people now in detention centres. There are still some, though, particularly given the overhang that was left the government by the previous government a couple of years ago now. But the makeup of people in our detention centres is changing because of that, because there are fewer people coming from overseas, and it's right and proper that we should seek to make sure that the powers that are available to our officers in those detention facilities are up to date. So we are committed, the government is committed to providing a safe and secure immigration detention network. The demography of our facilities, as I said, has changed. There are an increasingly proportionate number of people in detention facilities of high risk. They include people that have had their visa cancelled as a result of failing character tests, often due to convictions for drug or other serious criminal offences. There are people that are a high security risk, such as members of gangs. There are some that are subject to adverse security assessments, and some have become unlawful non-citizens as a result of breaching visa conditions. It's an unfortunate consequence that there are some people, of course, that in any population, be they in our local population or in detention facilities themselves, that aren't necessarily of a mind to do the right thing all the time. I followed last night a contribution by Senator Lyons from the Labor Party, and even she herself admitted that there would be a percentage of detention facility people who are a high risk. I think she put the number at around 120. I don't have precise figures, but Senator Lyons was arguing that 120 is not many, that we shouldn't need these extra powers only to deal with 120 people. Well, actually, I believe that even if there's 1, 2, 5 or 10 people that pose a high risk to the Australians that have to run these facilities, well, we should make sure that we give them the appropriate powers to make sure they can maintain their own health and safety in having to deal with these high-risk detainees. Because such detainees do, of course, create behavioural challenges, particularly those that want to or have committed crimes in the past. They can potentially jeopardise the safety, security and peace of our immigration detention facilities and the safety of all persons within those facilities. In fact, public order disturbances have arisen in a number of immigration detention facilities in recent years. The changes that the government is proposing here follow a review that was conducted into 2 of those incidents, one at Christmas Island, the other at the Villawood Immigration Detention Centre, both in 2011. The review was produced or prepared on behalf of the then Immigration Minister Chris Bowen and presented to him in 2011. And that report made a number of recommendations. One of which was to more clearly articulate the responsibility between the department, that's the Department of Immigration, the detention services providers such as Serco and private contractors who run these facilities, and any attending police services, because often when a disturbance does occur, police have to be called in, police often that are under the jurisdiction of a different government, of a state or territory government, and there's obviously a need to coordinate all aspects of an emergency response in those situations. These changes respond to that recommendation by clarifying that the officers, the authorised officers in Commonwealth detention facilities that are often employed by private contractors do have the ability to use reasonable force to maintain safety, to protect their own health and to protect the health of inmates themselves. There is increasingly need to provide this higher security, and the Migration Amendment Maintaining the Good Order of Immigration Detention Facilities Bill 2015, this bill is necessary to provide these officers with the resources needed to manage the safety, security and peace of our facilities. The bill amends the Migration Act 1958 to allow an authorised officer to use reasonable force against any person or thing as the authorised officer reasonably believes is necessary to protect the life, health or safety of any person, including the authorised officer, in an immigration detention facility, or maintain the good order, peace or security of an immigration detention facility. Without limiting the general power to use reasonable force, the bill in particular provides that an authorised officer may use such reasonable force as the authorised officer reasonably believes is necessary to, and the bill itself lists a number of things the authorised officer can do in that instance, including protect a person from harm or threat of harm, protect a detainee from self-harm or the threat of self-harm, prevent the escape of a detainee, prevent a person from damaging, destroying or interfering with property in a facility, move a detainee within an immigration detention facility, or prevent action in an immigration detention facility by any person that endangers the life, health or safety of any person or disturbs the good order, peace and security of the facility. The bill does use the legal concept reasonable force to limit the actions that can be taken by an authorised officer. There are particular provisions in this bill which limit that power to ones that are reasonable, and that is outlined as being that the authorised officer must make sure that in using reasonable force that only enough force is used to protect the life, safety or health of other persons. Reasonable force itself, as I did explain briefly last night, is not a new concept the government is inserting into this bill. It is a concept that is known in our common law, and indeed authorised officers today would have the general right to use reasonable force to protect their own safety and the safety of others. However, there is not a definitive definition in our common law of what that means, and that means that there's quite a bit of uncertainty for authorised officers in what they can and can't do to protect themselves and others. All this bill does is simply provide a codified and definitive outline of what reasonable force can reasonably be expected to be for authorised officers. I believe it is only fair and proper that we provide our officers that are putting themselves at duty for us with that certainty, with that environment that lets them do their job with sufficient understanding of what they can do, without the uncertainty of being subject to legal claims subsequent to an event that may cause them difficulty in managing a particular incident. This bill does reflect the rights and privileges that are provided to other officers in state and territory environments. Obviously, police forces have such rights and privileges, but even more comparative or more reflective of this bill is that often wardens and other officers in state or territory prison facilities would have similar rights and privileges under state and territory acts. And often, of course, in modern times, those officers are also employed by private contractors in a state or territory environment. This bill simply does reflect those state and territory provisions into a Commonwealth legal environment, into Commonwealth detention facilities that the Commonwealth Government is responsible for. It is a change that will help provide for greater security and order in our detention facilities. Hopefully it contains provisions that won't need to be used very much, and they certainly won't need to be used much if we continue to be able to protect our borders and make sure that people aren't arriving here in an illegal or irregular fashion. I hope that this government, I'm sure, will certainly maintain its vigilance in keeping people out of this country, and I hope any future government follows the lead of this government in maintaining that security and continuing to provide a strong border protection framework for Australia.
Thank you, Senator Canavan.